Hello everyone, my name is Al Parsai. I'm a regulated Canadian immigration consultant. I'm also the author of 88 Tips on Immigration to Canada, and I'm an instructor at Ashton College. I teach immigration consulting. I have written more than 1,200 articles and blog posts about different aspects of immigration to Canada. In this session, I would like to talk about inadmissibility to Canada. Hopefully we will cover these topics in this session. So we will focus on what is inadmissibility, then who is inadmissible to Canada, what kind of law governs inadmissibility to Canada, and eventually what are the remedies for inadmissibility. If you are inadmissible to Canada, can you resolve the issue? So without further ado, let's talk about inadmissibility. The first thing first is that inadmissibility means that if you are outside Canada, then you cannot enter Canada anymore, as long as you are inadmissible, unless it is resolved. If you are inside Canada and you become inadmissible, then you need to leave Canada as soon as possible. That's the whole concept behind inadmissibility to Canada. Now, with respect to the immigration law, we have foreign nationals to Canada, we have permanent residents of Canada, and we have citizens of Canada. Inadmissibility law does not affect Canadian citizens, but it may or may not affect some permanent residents of Canada. It definitely could affect every single foreign national of Canada. So let's take a look at different aspects of inadmissibility, and we explore which one affects foreign nationals, which one affects permanent residents of Canada. The law that is behind inadmissibility is called the Immigration and Refugee Protection Act, or IRPA. In fact, section 33 to 43 of IRPA talks about inadmissibility to Canada. I'll try to cover some of those sections. I also mentioned the section names because some of the viewers may be practitioners and they would like to know what I'm talking about. So the first section that I would like to cover is section 34, which is security. So a person can be inadmissible to Canada because of security reasons. And when we talk about security reasons, we are talking about, for example, matters such as terrorism, such as being a spy for a country that works against the beliefs and values of Canadians. Those kinds of activities could result into inadmissibility under security grounds. Security, or section 34, affects both permanent residents of Canada and foreign nationals. And by foreign nationals, I mean somebody who is a student, international student, foreign workers, visitors to Canada, or people who are stateless or illegally in Canada. And section 35 talks about human rights violation. So if somebody has violated human rights as defined by international conventions, then that person could be inadmissible to Canada. Again, section 35, just like section 34, affects permanent residents and foreign nationals. Section 37 talks about organized criminality. I intentionally skipped 36, we will talk about it. Section 37 means organized criminality, and that basically means you are a member of a gang, a member of a criminal group. If a person has been a member of a criminal group or is a member of a criminal group, then that person becomes inadmissible to Canada. Again, 37 affects both permanent residents of Canada and foreign nationals. These are the most difficult sections of the law for inadmissibility. If somebody is inadmissible under any of these sections, finding a solution for them is not easy. Albeit sometimes we can find solutions, but generally speaking, it's not easy. And when we reach to the end of this presentation, I will explain to you some of those options. But what about criminality? So if you look at section 36 of the Act, it divides criminality into two groups: serious criminality and criminality. Serious criminality is defined under subsection 1 of section 36, and criminality is defined under section 2, subsection 2. Let's first talk about serious criminality. When we talk about serious criminality, we need to see whether the criminal offense occurred inside Canada or outside Canada. If it occurred inside Canada, then both the duration of incarceration or penalty is important, and also the maximum penalty that is defined by the law. If somebody is convicted by an offense inside Canada and the maximum penalty for that offense is at least 10 years, then that person is inadmissible to Canada because of serious criminality. On the other hand, if somebody has committed an offense and they put him in jail for at least 6 months, then that person also becomes inadmissible to Canada under serious criminality. So either or. So the maximum penalty is at least 10 years, or the actual prison time is more than 6 months. Any of those could result into serious criminality. And what usually happens is that the person is imprisoned, and then when their prison time is over, they immediately deport them from Canada. That's for offenses inside Canada. If the offense is outside Canada, then we need to find out the equivalency of the offense inside Canada. And then if that offense inside Canada is indictable and the maximum penalty for that is at least 10 years, then that person becomes inadmissible to Canada. The actual duration of penalty or imprisonment outside Canada is usually or most likely irrelevant, but the equivalency in Canadian law is important. Okay? So this is different between That's the difference between outside Canada and inside Canada, that inside Canada, the duration of prison time could be also important, but for outside Canada, it is not important. Serious criminality unfortunately affects both foreign nationals and permanent residents of Canada. For example, starting from December 18, 2018, if somebody drinks alcohol and drives, and that person is convicted under a DUI or driving under influence, this is considered serious criminality, because since that time, the duration of prison is 10 years. And that's why even a permanent resident of Canada who receives a DUI could be inadmissible to Canada. What about criminality? So criminality is for those offenses that we could say they are indictable. Usually we have two different kinds of offenses in Canada: summary conviction and indictable offenses. Summary convictions are usually less severe. The jail time is usually less than 6 months, although we have summary convictions that the duration of jail time is more than 6 months. But generally speaking, if somebody is convicted with summary conviction, they receive fines, they may serve a few days in prison, those kinds of things. But with indictable, not necessarily, but usually the prison time in the law could be 6 months or more. And also it reflects that this is a more serious kind of crime. So under section 36 sub 2, if the offense occurs inside Canada and that offense is considered indictable, then this becomes criminality. If it's summary conviction but occurs more than once, so one, for example, in 2015 and one in 2020, then that is considered, again, criminality. So more than one summary convictions, or just one indictable conviction could result into criminality, inadmissibility because of criminality. If the offense is outside Canada, then we need to see the equivalency in Canada and whether it is an indictable offense or not. But generally speaking, criminality only affects foreign nationals. It doesn't affect permanent residents of Canada. And resolving inadmissibility because of criminality is a lot easier than resolving inadmissibility because of serious criminality. Section 38 of the Act talks about health grounds. A person could be inadmissible to Canada because that person negatively affects the safety of Canadians, the security or health of Canadians, and also that person causes excessive demand. So what does that mean? So the first one are about those kinds of problems, health problems that are dangerous to Canadian public. And right now we have untreated syphilis and active case of tuberculosis or pulmonary tuberculosis on the list of those illnesses that make a person inadmissible to Canada. But at the end of the day, the minister could also identify other issues and make a person inadmissible because of those issues. The second group that talks more about the safety of Canadians is reflects those kinds of issues that results into harm to Canadians. For example, certain mental health issues. If somebody is suffering from some psychopathic behavior that could kill other people or harm other people, or if somebody is a pedophile, or if somebody drinks excessively and drives and they have lots of DUIs, and that shows that this person could put people's lives in danger, and certain schizophrenia issues that result into harm to others, then that person could become inadmissible to Canada. This is not about mental health. So many mental health issues like depression, anxiety, those kinds of issues, they never make a person inadmissible to Canada unless they are very severe and cause excessive demand. And excessive demand, of course, means that the person puts too much financial pressure on the healthcare system in Canada, or it causes long wait times for Canadians to receive the health services they want. Luckily, starting from 2018, the government of Canada made some changes to excessive demand. Now, roughly speaking, about 70% of people who used to be inadmissible to Canada because of excessive demand, they are not inadmissible to Canada anymore. Section 39 talks about financial reasons. And this section, by the way, Section 38 only affects foreign nationals, not permanent residents. The same thing is true for Section 39. If somebody wants to immigrate to Canada, they need to show that they are capable or willing to be in Canada financially independent. So if somebody is coming to Canada to abuse our healthcare system, to use our social welfare system, that person could become inadmissible to Canada. You have to be very careful about this. Section 40 talks about misrepresentation. When somebody files an application to immigrate to Canada, that person needs to be truthful and needs to present all necessary documents that are related to the decision making of the officer. So if somebody hides critical information, or as the government calls it, material fact from the officer, those kinds of pieces of information that affect the decision making of the officer, then that person has misrepresented. The other option would be that somebody falsifies documents or forges documents or presents documents that they are not real. So any kind of meddling with the real documents, that could also result into misrepresentation. Misrepresentation creates inadmissibility to Canada for 60 months. So in other words, if somebody is inadmissible because they misrepresented, they become inadmissible to Canada for a period of 60 months. And then after the 60 months, they may apply for immigration again. That's unlike the other inadmissibility issues that they are usually forever, for as long as that underlying issue has not resolved. With this one, even if you resolve the underlying issues, which I don't know how you can do that, you still need to wait for 60 months. So at the end of the day, misrepresentation is a very dangerous thing that occurs to an applicant because you cannot immigrate to Canada, you cannot file for immigration. All of those are not an option for you anymore. But after 60 months, you can apply again. Okay? Section 41 talks about non-compliance with the Immigration Act. This section, I can give you some examples, that's better. It could apply to many things, but two examples would be somebody who is here in Canada and is working without proper work permit. So if somebody is not allowed to work or not allowed to work for a certain employer, and that person starts working in Canada, then that's non-compliance, and that person, if caught by CBSA, becomes inadmissible to Canada. The other example would be a permanent resident of Canada who doesn't comply with the residency obligations. If that person tries to enter Canada and they realize this permanent resident does not meet the requirements of the Act anymore, then that permanent resident immediately becomes inadmissible to Canada. In these two examples, of course, if these two cases, they leave Canada and then they apply for coming back to Canada with another kind of application, they might allow them to enter Canada, and the inadmissibility will be resolved. So that inadmissibility would be a very temporary inadmissibility. Section 42 is one of those sections that we don't really like to hear about, but if a family are applying for immigration to Canada and one of the family members is inadmissible to Canada, the rest of family members become also inadmissible to Canada. Keep in mind that when we talk about family members, we are talking about the principal applicant and then the spouse of that principal applicant or common law partner or conjugal partner of that applicant, and also their dependent children. And these are the children who are not married and they are under the age of 22, or under certain circumstances, despite being over 22, they are dependent children. So one inadmissibility by a family member could affect the immigration of the rest of family members, at least under that specific application. Okay, we're done with the definition of who is inadmissible to Canada. Now the question is that what are the remedies for inadmissibility? And those remedies are also defined under IRPA, or Immigration Refugee Protection Act, and also Immigration Refugee Protection Regulations, and some internal guidelines by the immigration authorities. Obviously, the first one is prevention. Try to prevent from being inadmissible to Canada. So if you are suffering from an acute disease, try to resolve that issue first and submit your application. Or do not lie on your files, or make sure that first you try to apply for, let's say, for a pardon and resolving your criminality issues, apply for acquittal, and then apply for immigration. In other words, you can apply for immigration to Canada after you resolve all the problems that could potentially result into your inadmissibility to Canada. But this is not always an option. What should we do then? Okay, first, what if the immigration officer made a mistake and you are not in fact inadmissible to Canada? So that was their mistaken understanding of the situation, your application. In those situations, we have the court system. Under certain circumstances, we can file with the Immigration Refugee Board of Canada to resolve that, or we could file with Federal Court of Canada for judicial review. And then based on the judicial review application, if you win the case, if you win the IRB case, then the problem is resolved and voila, you're not inadmissible to Canada. Another option would be, if now we are talking about situations that actually you have lost your court cases or the officer is right and you are inadmissible to Canada. In those situations, there are certain options. One of the options is called humanitarian and compassionate grounds, which is you can make an application under Section 25 of the Act. And this is mostly useful for people who are already inside Canada. But unfortunately, it does not apply to Section 34, 35, or 37 of the Act. In other words, if the inadmissibility is because of security, because of human rights violations, or because of organized criminality, HNC is not an option. You cannot apply under HNC. But for other options, for other situations, you might be able to apply for HNC. And the success rate under HNC is not very high. And that's why you need to be very careful and make sure that you have a strong case for application. The other option is called rehabilitation. And this option is available for inadmissibility under Section 36. If somebody is inadmissible because of criminality or serious criminality, then depending on the duration of from the day that they submit their application to the day that they completed their sentencing and everything. So they look at that, and under certain circumstances, they may submit application for rehabilitation. In most cases, that means at least 5 years has passed from the day that you completed your sentence, paid your fines and everything. Then you may apply for rehabilitation to the immigration authorities. It's a relatively difficult process, but if they are convinced that your application makes sense, they consider the person rehabilitated, and by receiving a positive response on rehabilitation, the inadmissibility is completely resolved, and that person can apply for any kind of immigration or visa to Canada. It doesn't guarantee approval of those applications, but at least that person is not inadmissible. Under certain circumstances, for less severe criminality, inadmissibilities to Canada under Section 36(2), if a long time has passed from the time that the person was inadmissible, we could consider that person deemed rehabilitated. It means that you don't even need to submit an application. You just mentioned that criminality occurred 20 years ago, and since then I didn't commit anything, and I'm not inadmissible to Canada anymore. For deemed rehabilitation applications, in most cases, the case needs to be only criminality issues, and at least 10 years has passed. Now we have some exceptional situations as well. And then we also have the option of record suspension for inside Canada cases, that if you receive record suspension or acquittal inside Canada, then you are not inadmissible to Canada. If rehabilitation is not an option, you can apply for TRP, or a temporary resident permit, which temporarily allow you to enter Canada from 1 day to 3 years. And if the inadmissibility is under, and we talked about TRP before, so I won't repeat it, see my first video, but if your inadmissibility is under Section 34, 35, or 37, another option would be asking for ministerial relief under Section 42.1 of the Act. If the minister approves that, or the officer approves that, then the person can enter Canada despite being inadmissible because of security issues. And that concludes my video about inadmissibility. I hope you enjoyed it.